What is the impact of an assignment on the relationship between an account debtor and a secured creditor? To find out, you have to read Worthy Lending versus New Style. It's only 10 pages. Don't have time for that? I got you covered. TLDR, too long didn't read New York Court of Appeals on the case of Worthy Lending versus New Style Contractors. This is found at 2022 New York Slip Opinion 06631, published by the Court of Appeals on November 22nd, 2022. This is a case where it's a civil case where the issue is application of New York's Uniform Commercial Code, Section 9-406, which is about assignments of security interests and how to actually accomplish an assignment of a security interest. The general process under Uniform Commercial Code 9-406 is that the assignee, the person who's assigned the interest, like a bank that has given a promissory note, has to notify the account debtor, which is a person who owes money to the assignor, to say, I'm the new assignee. You have to pay me instead of the assignor, the person who you had previously promised to pay. At that point, the account debtor, the person who owes the money originally to the assignor, has one of two options. The first option is to start paying the assignee, the bank, or can request proof of the assignment, can say, I don't want to start doing that. I want to keep paying the assignor until I am protected by proof that you actually do have an assignment of the rights that I had previously owed to the assignor. And the danger of failing to do either of those things, either paying the assignee or demanding proof or requesting proof of the actual assignment, if you keep paying the original person that you promised to pay, is you may have to pay twice, because now you're paying the assignor, but that's not relieving the debt. You now have to also eventually pay the assignee when they bring you to court and say you didn't follow Uniform Commercial Code 9-406. Now, in this particular case, there's a company called Checkmate, and Checkmate lent or had a contract with New Style, where New Style was paying them money. And then Checkmate went to a bank, went to a lender, Worthy Lending, and borrowed $3 million. Worthy Lending had a secured interest in that promissory note, and also had in that security agreement also had a right, according to the agreement between the lending organization and Checkmate, to all the assets and agreements that Checkmate had, including the agreement with New Style. And they did what they were supposed to do under Uniform Commercial Code 9-406, and they notified New Style and said, we are the assignee now. You pay us now. New Style didn't take any of those two options, did not either pay Worthy Lending and did not demand or request proof of the assignment. They just kept paying Checkmate. Checkmate went bankrupt, of course, and Worthy now goes after New Style and says, where's the money you owe us? And New Style said, I've been paying Checkmate. And so they sue. Worthy sues New Style and says, I don't recognize the money that you paid to Checkmate. I never got it. And I had complied with Uniform Commercial Code 9-406. And the lower court, the procedural history here is the lower court said, you have no privity. You don't have a contract relationship between yourself, the lending organization, and New Style. And there's no agreement between you. And Uniform Commercial Code 4-06, the last part of it says that there's no duty between, this does not create a duty between an account debtor and the lender. The appellate division agreed with the trial court, but it comes to the Court of Appeals and they say no. Stop focusing on the word assignee. The lender had a secured interest in all of the accounts receivable. That's the same thing as an assignment. They're sending a notice to New Style, the account debtor, that they were the new assignee, and New Style failing to do one of those two things that they're required to do, either start paying Worthy Lending or to request proof of the assignment, means that the person who's at fault here is New Style. That there's no distinction between the word assignment, that assignment also includes having assets including accounts receivable or contracts for accounts receivable. So the holding of the Court of Appeals is that Uniform Commercial Code 9-406 includes, under the word assignment or assignee, a person who has a secured interest or security interest in the accounts receivable. If you like what you just saw and you want more of it, please hit like or subscribe to let me know.